EncroChat, when French justice crossed Europe's red line. In 2020, France led an unprecedented operation against the encrypted network EncroChat, installing spyware on the terminals of thousands of users. What started as an operation against organized crime has ended up opening a deep crack in the European rule of law, the use of massive and transnational methods without judicial control in the countries concerned, and without respecting the limits of territorial competence. Malware did not stay in France. The intervention was authorized by a liberties and detention judge of the Lille court, who ordered the installation of spyware directly on EncroChat phones, wherever their users were. This involves direct interference on devices located on foreign territory, which clearly exceeds the competences of a national judge and violates the principle of judicial territoriality. This was not merely passive interception. The malware made it possible to read encrypted messages in real time, access files, obtain screenshots, and even activate the device's microphone and camera. These interventions took place without the knowledge or authorization of the judicial authorities in the affected countries, such as Spain, Germany, Belgium, or the Netherlands. National security. Whose? France justified this exceptional measure on the grounds that EncroChat posed a threat to its national security. In other words, the perceived risk was so serious that according to its internal logic, it allowed it to take intrusive surveillance measures without waiting for judicial cooperation. However, invoking national security does not entitle one to infringe on the sovereignty of other countries or to illegally extend the jurisdiction of a French judge over foreign nationals. This argument, moreover, is problematic when it is established that the legal basis for the intervention was a French crime with no equivalence in other jurisdictions, which was the provision of cryptographic means without double authentication. France knew that it was invading other jurisdictions and did nothing. On April 13, 2020, the French judge was already fully aware of the exact number of phones and countries where communications were being tapped. This is acknowledged in the wiretapping orders themselves. Despite this, he did not activate Article 31 of the Treaty on European Union, which requires notifying the states concerned and obtaining their consent before implementing investigative measures that interfere with their jurisdictional sovereignty. This failure was not a technical error. It was a deliberate decision to omit mandatory judicial cooperation, violating the very basis of mutual trust between member states. France acted unilaterally, turning a domestic investigation into a covert mass surveillance operation on a European scale. Article 31 of the EU Treaty and the Berlin Judgment. Article 31 of the EU Treaty regulates criminal judicial cooperation measures and states that any action having effects outside the territory of the initiating member state requires communication to and consent of the state concerned. The omission of this procedure delegitimizes evidence obtained outside the legal framework. This was the understanding, for example, of the Berlin Regional Court, which in a landmark judgment acquitted an accused drug trafficker by considering that the messages intercepted by the spyware installed by France on the EncroChat phones provided as key evidence against him were obtained without complying with the minimum requirements of international cooperation. The Chamber concluded that France acted beyond its powers without triggering Article 31 of the EU Treaty or obtaining Germany's consent, rendering the evidence unusable at trial. Europol is C3 and the hidden role in decryption. For years, it has been officially maintained that Europol acted only as a channel for transmitting information between France and the other member states. However, documents to which we have had access show that Europol's EC3, or European Cybercrime Centre, was not a mere observer, but actively collaborated in the process of decrypting the intercepted messages. This direct technical involvement has been deliberately concealed, probably because of the dubious legality of its participation, which lacked a European judicial mandate or cover under a European investigation order. The involvement of a supranational police agency in the access and processing of private communications without express legal basis, outside any jurisdictional control of the country concerned, seriously compromises the legitimacy of the whole process. The civil guard also crossed the line. According to official documentation to which we have had access, the Central Operational Unit of the Civil Guard UCO, in its money laundering group, sent to France through the police channel Siena detailed information on Spanish businessmen, their companies, personal relationships and corporate environment in February and March 2020. That is, even before the formal opening of judicial proceedings in Spain. This transmission of data was made without any European investigation order, without rogatory commission, without judicial control, and without regulatory legal basis. It was a unilateral transfer of police intelligence disguised as operational cooperation, which violates the principle of legality, the right to privacy, and the duty of effective judicial protection. But the problem did not end there. That information was later used as a factual basis to justify arrest and surrender warrants for Spanish citizens, in some cases for the enforcement of non-existent sentences, fabricated on the basis of police assumptions not verified by any competent court. What began as intelligence became accusation. What should have been dismissed as illegal became useful evidence. The EncroChat case has shown that, when boundaries are overturned, the terrain between surveillance, prosecution, and fabrication of charges becomes dangerously indistinct. And it seems that with EncroChat, anything goes. A clandestine civil guard? The case of Sergeant Bravo, revealed by economist and jurist, demonstrates that in the framework of investigations related to EncroChat, the Guardia Civil not only acted without judicial control, but even installed itself in a dynamic of operational clandestinity, falsifying attestations, placing illegal beacons and recording interrogations without a lawyer or court order. But this was not the only excess. The Guardia Civil itself created a secret tool called Detective EncroChat, used in a completely clandestine way to monitor in real time the location of EncroChat users, applying powerful search filters and linking people, terminals, and communications without leaving a trace. This platform was not audited, registered, or supervised by any judicial or administrative authority, and was developed outside the ordinary legal procedures. In addition, the data of all users were hosted on servers of a private company, with no guarantees of security or traceability. Today, it is known that this data has been stolen and is circulating on the black market, which poses a serious threat to the privacy and personal integrity of thousands of citizens. These practices, acknowledged by agents and investigators, were not one-off exceptions. They are part of a parallel institutional logic where the boundaries between intelligence, criminal investigation, and unchecked exercise of state power are annulled. Action is taken first and justified later. The rule of law cannot tolerate police forces acting as covert structures with opaque tools and without accountability. And yet, that is exactly what has happened with EncroChat, a clandestine investigation executed under the guise of judicial cooperation. The Audiencia Nacional is a mute witness of the abuse. Another of the most serious excesses in the framework of this operation was the physical displacement of the French judge in charge of the investigation, who travelled from Lille to the Spanish National Court to take statements directly from several persons residing in Spain, without channeling it through rogatory commissions. During these sessions held in Spanish judicial offices, the Audiencia Nacional acted as a blind and deaf witness, allowing the foreign magistrate to exercise judicial functions in Spanish territory without legal competence to do so. The judge of the Audiencia Nacional witnessed and allowed these abuses without intervening, despite the fact that essential procedural guarantees were violated. The persons called to testify were not informed of their legal status, whether they were called as witnesses or investigated, were denied legal assistance in some cases, and were coerced under the threat that arrest warrants would be issued if they did not collaborate, as if the Audiencia Nacional had become a subordinate branch of the French jurors. This episode reveals to what extent Spanish judicial sovereignty has been blurred, and how judicial cooperation can derive into institutional submission when clear limits are not established and the integrity of the national system is not protected. The 1620th proceedings, the black hole of the prosecutor's office. One of the most serious episodes in the EncroChat case in Spain was the opening of the 1620th investigation proceedings by the Anti-Drug Prosecutor's Office of the Audiencia Nacional. These proceedings, initiated in July 2020, were born precisely from the EncroChat communications provided by France through Europol. Despite this, these proceedings were kept hidden for months, without notification to the affected persons or formal prosecution. Finally, they were filed in June 2022 without any notice to the parties, which prevented any possibility of appeal or challenge. This decision was adopted without any jurisdictional control and without the intervention of any investigating judge. Far from closing the case, the information contained in these proceedings was sent to France apparently by means of an agreement between prosecutors and gave rise to criminal proceedings against Spanish citizens in French territory. That is to say, what could not be judicially sustained in Spain was recycled in France as a valid accusation, without respecting the right to defense or the principle of specialty. This maneuver is legally inadmissible. The Spanish prosecutor's office does not have the competence to prosecute in another country. Some investigation proceedings that, in Spain, were already filed without ever having passed the threshold of judicial legality. The transfer of these proceedings to France, without an order from a Spanish judge or formal procedure of international cooperation such as a European Investigation Order or Rogatory Commission, constitutes a serious violation of judicial sovereignty and the fundamental rights of those under investigation. Clashing interests and a disturbing submission. Beyond the legal level, the EncroChat case highlights a deeply uncomfortable political reality for Spain. The interests of the French state have historically been contrary to those of Spain, both in matters of sovereignty and security strategies. And yet, today, we see a silent surrender to French demands, without institutional debate or parliamentary control. While Spanish trucks are overturned at the border, exports are sabotaged, or blockades are imposed under the pretext of agricultural interests in the offices of Paris technological operations are authorized that spy massively on Spanish citizens without judicial control in Spain. With the complicity of our own forces of order and the absolute passivity of the judicial and political power. Moreover, cooperation takes place in a context of enormous criminal and procedural asymmetry. In France, if a police officer or gendarme stops a citizen and asks for his cell phone and PIN, refusal to hand it over can lead to a heavy fine or even imprisonment. Refusal to cooperate with the police, even in non-criminal contexts, is severely punished. Similarly, it is sufficient to have Spanish license plates for a vehicle to be stopped and searched for no specific reason. It is a common practice, covered by a broad interpretation of the principle of prevention, but in Spain it would be clearly unconstitutional if practiced by our security forces. And yet, the Spanish authorities accept without question the results of French investigations, even though they come from a system that is more repressive, more opaque, and less protective than ours. This imbalance is not only unjustifiable, it is alarming, because if it is normalized, it will consolidate a model where other states decide on the rights of Spanish citizens with more efficiency and power than our own institutions. A painful paradox for the Guardia Civil. The paradox is bitter. The Guardia Civil, without the backing of a Spanish judicial order or a formal open investigation, collaborated with a French operation that overflowed all international legality. It put itself at the service without questioning it of a French state logic that ignored Spanish judges, violated fundamental rights, and extended its jurisdiction as if Europe were a zone without limits or rules. All this while France has been a historical refuge for dozens of ETA members, many of them responsible for attacks against agents of the Guardia Civil. For years, the French state offered asylum, protection, or indifference to those who did represent a real threat to Spanish national security. The question is inevitable: how can it be justified to cooperate blindly now with a state that then refused to collaborate against terrorism, and that today asks for obedience in massive surveillance operations without judicial control or concrete penal cause? Conclusion: Europe at the crossroads. EncroChat was not just a technical operation. It was a legal and political challenge to the legal framework underpinning European justice. Mutual trust between states can only be maintained if the rules are respected. Limited jurisdiction, judicial control, formal cooperation, and respect for fundamental rights. France chose to act alone, to ignore its partners, and to extend its power beyond its borders. If Europe legitimizes this precedent, opens the door to justice without limits, without sovereignty and without guarantees. And then, yes, the real risk will no longer be organized crime, but the slow and silent erosion of the European rule of law.